Welcome to Coastal Funeral Center and our community partnership video series on trust. My name is Sharon Kalani and I direct business operations here at Coastal Funeral Center. Our subject today is, what is a living trust? And I am honored to introduce you to Laura Thatcher, founding attorney of Blue Water Estate Planning. She's going to be our expert today. Thank you, Laura, and welcome.
Well, thank you so much for having me. I really appreciate it.
Our honor and pleasure. So what is a living trust, Laura?
So I like to use an analogy of a treasure chest when I talk about living trusts, because it's a legal document and most of us don't speak legalese. So a living trust is just a treasure chest that we store the things that are most important to us, or the assets that are most important to us. And it has several different features. One is it has a person who holds the key to the treasure chest. They're called a trustee. And then it also has a book of instructions, and that's the words of the trust that say what the trustee can do with the assets stored inside the trust and who the assets will go to. A living trust has several features that I really love. One feature of a living trust is that everything that you've stored in the living trust can be taken care of by the person with the key. And if the creator of that treasure chest is incapacitated for whatever reason, there's a successor key holder, a successor trustee that can manage the assets in that treasure chest for the creator of the treasure chest. And then when the creator of that treasure chest dies, the instructions say what happens to those assets.
That's a very interesting analogy and one that's very easy to understand. Thank you for that. So who should have a living trust?
Well, not quite everyone, but almost everyone can benefit. Every adult, once you turn 18, you need some form of estate plan. Even if it's just answering the question, who takes care of me if I can't speak for myself? So that would be a power of attorney and an advanced healthcare directive. We graduate to needing a living trust when we have more in our life to take care of than, say, your typical 18-year-old. If you own a home, you absolutely need a living trust, because otherwise that home, in order to go to your loved ones, has to go through a process called probate. And that is a court-sponsored process where a judge says the assets that belong to a person who died now belong to their beneficiaries or heirs. And the beauty of a living trust is everything held inside that treasure chest doesn't have to go through that court process.
When you want something to be in your trust, does it have to be named in your trust? Because I know that, at least in my profession, if someone owns interment privileges or a space at a memorial park, if the ownership has not physically been changed into the trust, it's not considered in the trust and now becomes something outside of the trust, subject potentially to things like probate, but also to ownership. Who owns it then? And a lot of people, again, think just because they have a trust, everything goes in it, like a pour-over.
Gosh, yes. Well, there is a pour-over. So there is a process where what's called a pour-over will, and that scoops anything that you forgot to put in the trust and puts it into the trust.
But not everybody recognizes.
Well, they do, but it has to go through probate.
Right.
In some form. So the nice thing about having that pour-over will is it makes sure that the assets that you want to follow the instructions for the trust, that they will follow those instructions, but you have to go eventually. And probate is long and expensive and public. So we don't necessarily want to use the probate process. So to put an asset in the trust, again, we'll go back to the treasure chest or a corollary, a toy box. You just put a label on the asset. And putting the label to do that, if you have a bank account, you go to the bank and you bring your trust and you say, I created a living trust. I want my bank account in the name of the trust. Or if you have a home, you deed the home from yourself as an individual to the trustee of the trust. And for my clients, I take care of making sure that at a very minimum, their home is in their trust. And then we work with them over the course of the year after we sign the documents to make sure that their other assets are transferred properly. One of the features that we take advantage of is for blended families. So a lot of times, blended families, the mom wants to make sure her children are taken care of, and the dad also wants to make sure that his children are taken care of. Yet they have assets from both sides of the family. With a living trust, we can create a treasure chest that splits up at one spouse's death, so the mom can make sure that her children are taken care of, even if she is the first to die. And then the dad can do the same. But the assets can be used for the surviving spouse as well. To create a trust, you do have to be an adult, because anyone under 18 can't sign legal documents. So you do have to be an adult, but you don't have to be an adult to have a trust. When I die, my children are the beneficiaries of my trust, and I actually want all the assets to stay in trust for them so that my children are protected from their mistakes or non-mistakes. If they were to get into a car accident, only a little bit their fault, only 1%. But let's say they were hit by a drunk driver, and that drunk driver has no money, no insurance, and they rear end my child driving and pushes the car into the front of them and then into the intersection, and there's just a great giant pile up. And then everyone sues, and the court finds that my child was 1% at fault and the drunk driver was 99% at fault. Under the law, if you're 1% at fault, you are responsible for up to 100% of the damages. So if I give my children assets in a trust, it can't be taken away from them involuntarily.
Interesting.
It's a little more complicated than that.
Right.
But there are ways that I can protect my children's inheritance from the world around them, and sometimes from their bad decisions too. So young people can't create a trust, but they can benefit from a trust. And that asset protection is one of the things that I tend to very strongly recommend to my clients. It's what I've done for my children, but it doesn't have to have that. One thing to mention when I say asset protection, a living trust, which is a revocable document, it can be changed at any time. Mm-hmm. And because the creator can change it at any time, those assets belong to the creator. And that means that if the creator is sued, the assets that are held in their living trust do not receive asset protection. And that's one of those myths about creating a living trust. Oh, I'm going to protect all my assets. Oh, if I have a living trust, I don't have to pay estate tax. It's not entirely true. Most people aren't going to need to worry about estate tax because at the moment it is the threshold is very high. It's almost $14 million per person.
I didn't know that.
That will change in 26 to approximately $7 million per person.
So is that $7 million per person, meaning $7 million of protection for a husband, $7 million for a wife, for a total or $14 million?
Exactly. And that's protection from estate tax. And it's not really protection, it's exemption. If you have less, your estate does not have to pay tax.
Understood.
And anything over that, they only pay tax on the difference. If I had $8 million, my estate would only have to pay tax on $1 million. That first 7 is not taxed. And that the exact amount of the estate tax exemption changes from year to year, and that information can be easily looked up. What's the estate tax exemption in 2024?
How often should you review your trust?
Well, I'd say at a minimum every 3 to 5 years. Laws change, especially in the estate planning. It typically doesn't change very often, but sometimes it can change drastically. Like the change in estate tax from $14 million per person to $7 million per person. That's going to be a drastic change that might cause people to adjust their estate plans. Mm-hmm. But also circumstances in our lives change. We get divorced, we get married, we have children, we have grandchildren. We have loved ones who get into situations that we want to protect them from. And sometimes the trust that we create 10 years ago doesn't fit our life today. And that's actually why they're called living trusts, because as our lives change, they're living, breathing documents, but they can be changed to match our lives. I actually offer a service for my clients that we call our Smooth Sailing Program. And for the first year after creating a document, or not a document, but an estate plan, if you have changes, whether they're small or large, we do those for free for our clients. Because I think it's more important to make a decision now than have it be the perfect decision. And making those decisions can be very, very hard for people. So I encourage people to just pick someone. And if you change your mind over the course of the year, we'll fix it.
And what about having a single trustee versus co-trustees?
Co-trustees?
Because I've kind of experienced in my past careers and current careers some of the challenges associated with co-trustees.
So my personal preference is to have one person act at a time, with the exception of someone who needs asset protection and they want to act as their own trustee. They need to have an independent co-trustee to actually give that asset protection. But in general, I am not a big fan of co-trustees, because if you have two people and there's a deadlock, who's the tiebreaker?
Who else can benefit from a trust?
Well, families who have children who are spaced far apart. Sometimes families will have a 19-year-old and a 2-year-old. If the parent dies, that 19-year-old has gotten all of the financial benefit to get them that far, but the 2-year-old hasn't. So if I were to split all of my assets equally between my 19 and my 2-year-old, penalizes is not necessarily the right word. It puts the 2-year-old at a little bit of a disadvantage. So what we can do is something called a family pot trust. So in that, when both parents die and the children become the beneficiaries, everything stays in one treasure chest until the youngest reaches a designated age, or circumstance in life. When my youngest turns 25 or graduates from college, whichever comes first, then the family pot trust is split. The oldest gets their half. The rest is held for the youngest until they reach a target age, say 30 or however old a family thinks is the best age for the beneficiaries to get their inheritance. But it's a way of making sure that all children they're not going to receive the benefit of having their parents, but at least they'll have the same resources. That's the whole point of having an estate plan, is to make sure that you are taken care of if you can't speak for yourself, and your loved ones are taken care of when you're no longer there.
Laura, thank you so much for participating in this community partnership series of informational videos that help people to start to understand estate planning, wills, and trusts. I'm grateful for your time, and I'm also thankful for all of you that are participating by watching today. And Laura, if they would want to get a hold of you to ask you additional questions, how would they do that?
Well, probably the easiest thing would be to call my office, and the number should be on the bottom of the screen, and I am happy to talk with them. One of my favorite things is to educate the public, and my clients in particular, about what they can do for their families.
You and I have that in common, and again, I'm so grateful you joined us today. And if you would like any additional information from us, please feel free to call Coastal Funeral Center at 310-326-6343 or visit us on our website at coastalfuneralcenter.com. Thank you.